There's a reason no employer ever sits you down on your first day and carefully walks you through everything you're legally entitled to, because the system runs more smoothly for them when you don't know. Every right you've never heard of is a right you'll never use, and a right you never use is one they never have to honour. None of this is actually hidden. It's written down in law. It's just that nobody points you to it. Nobody explains it, and by the time you need it, you're usually too stressed, too rushed, or too frightened to go looking. So today, I'm going to point you to it. 10 rights you have at work in the UK that your employer is quietly hoping you never learn, what each one really means, and how to use it. One important note before we start. This is general information, not legal advice. For your own situation, ACAS, Citizens Advice, or a solicitor are the people to call. And because employment law genuinely changes, treat the specifics as a reason to check the current position, not gospel. But the principle never changes. People who know their rights get treated very differently from people who don't. Let's make sure you're the first kind.
It starts on your very first day. You're entitled to a written statement of your main employment terms, your hours, your pay, your notice period, your holiday. And in the UK, that's now a day one right, not something they can drag out for weeks. Why do they hope you don't notice? Because a vague, missing, or never provided contract works in their favour, not yours. If the terms were never written down, they're a lot easier to quietly change later. So get it in writing, read it properly, and keep your own copy somewhere that isn't your work email. The day you actually need to know what you agreed to is the worst day to discover nobody ever told you.
You've been called to a disciplinary or a grievance meeting, and the unspoken assumption is that you turn up by yourself, outnumbered, while they have HR and your manager on their side. Here's what they rarely volunteer. You have the legal right to be accompanied at a formal disciplinary or grievance hearing by a colleague or a trade union rep. That one person changes everything. They take notes, they witness what's said, and they stop you facing a room full of the company's people on your own. Never go in alone if you don't have to, and you almost never have to. For years, the story was that flexible working was a favour you earned after you'd been somewhere long enough to deserve it. Not anymore. In the UK, the right to request flexible working is now a day one right, and your employer has to deal with your request properly and within a set time, not just ignore it. It's a request, not a guarantee. They can still say no for genuine business reasons, but we don't do that here, isn't a lawful answer. Make the request properly, in writing, and make them give you a real one back.
You're entitled to paid annual leave, 5.6 weeks a year for a full-time worker in the UK. That part most people know. Here's the part they're quieter about. Your holiday pay is supposed to reflect what you normally earn. So if you regularly do overtime or earn commission, that can count toward it. And if you leave a job with holiday you never took, you're usually owed pay for it. So check your payslips against your actual leave. Underpaid holiday is one of the most common quiet shortfalls there is, and it's your money, not a gift. If you work more than 6 hours, you're entitled to a rest break. You're entitled to daily and weekly rest. And there's a limit on the average working week. And crucially, you decide whether to work beyond it, not them. A lot of workplaces lean on a culture of we just get it done and let those rights quietly evaporate. That culture is not the law. You don't have to make a scene about it, but know that everyone here works through lunch is a habit, not an obligation, and the limits exist to protect you, not to be apologised for. You open your payslip and something's missing. a deduction for a till shortfall, a mistake, a bit of kit, training costs, taken without a proper conversation. In most cases, your employer can't lawfully make deductions from your wages unless the law allows it, your contract clearly allows it, or you've agreed to it in writing. Surprise deductions are often unlawful. So if money disappears from your pay that you didn't agree to, that's not just annoying, it may be a breach of your rights. Query it in writing and keep the reply.
Under the Equality Act, you're protected from being treated worse because of who you are. Your race, sex, age, disability, religion, and other protected characteristics. That covers discrimination, harassment, and victimization for raising it. This is the one that gets quietly buried under culture fit, the wrong tone, and it was just banter. Putting a friendly label on something doesn't stop it being unlawful. You don't have to be certain to take it seriously. Write down what happened, when, and who saw it. Dated, factual, saved somewhere safe. A clear record turns "I felt singled out" into something with weight behind it.
If you report something genuinely wrong at work, fraud, a danger to health and safety, a legal breach, there are protections for that. It's called whistleblowing, and a protected disclosure isn't supposed to cost you your job or your standing. Employers count on the fear, the sense that if you say anything, you'll be quietly punished for it. The law exists precisely because that fear is real. If you're ever in that position, get advice before you raise it. How and to whom you report it matters a great deal. ACAS or a solicitor can walk you through doing it the protected way.
You can't always be sacked just because someone feels like it. Protection from unfair dismissal is a real thing, though the exact rules, including how long you need to have worked there, are changing in the UK right now, so check the current position before you rely on it. And here's the free tool they don't advertise. Before most employment tribunal claims, there's ACAS Early Conciliation, a free service that tries to sort things out without a courtroom. It costs nothing to start, and even starting it changes how seriously you're taken. You don't have to leap to a tribunal, but knowing the path exists and that it's free to begin quietly puts you on more equal footing.
And the one they hope you never learn. Under UK data protection law, you can make a subject access request and require your employer to hand over the personal data they hold about you. That can include emails that mention you, notes from meetings, parts of your HR file, the conversations that happened about you in rooms you weren't in. Usually free, and they have to respond within a set time. You don't fire this off lightly, but if you ever genuinely believe you're being managed out, set up, or treated unfairly, a subject access request is one of the most powerful, least known moves you have. The paper trail they built quietly, you're allowed to read it.
Notice the thread running through all 10. Not one of these is a secret. Every single one is written down, freely available, sitting in plain sight. They're only hidden because the quiet expectation at work is that you'll never go looking, that you'll assume the rules are whatever your employer says they are on the day. But the moment you know what you're actually entitled to, the whole balance shifts. You stop asking permission for things that are already yours. You don't need to memorize the law. You just need to know these exist, so that when the moment comes, you know there's somewhere to look and someone to call. Save this one. You'll want it one day. If this helped, subscribe.